don't forget that there have been a string of recent Supreme Court cases that it's really important to make sense of to see where healthcare law might be going in the UK. So you have to think about the impact of the Nicholson case. Nicholson was testing out the extent to which things were for Parliament and things were for the judges. And the judges seem to be flexing their muscles and saying that where issues are fundamental human rights, particularly respect for autonomy rights under Article 8, then there are limits on democratic decision-making on issues of medical ethics. And they do that in the context of assisted dying. And then you've got Noncom Reef, which seems to say that the judges know better than doctors, at least in relation to disclosure requirements, what's required by human rights. And they leave open the extent to which that undermines the whole of the Bolan philosophy, or whether it's particular to the context of informed consent disclosure requirements. You've got Dugan on the conscientious rejection rights of midwives, and that explores the extent to which we have a set of rules that everybody is expected to abide by, or the extent to which that being a professional enables you to opt out. So that's really important. And then you have two cases involving withdrawal treatment, Aintree and James, and N and ACCG, which we looked at. It only came out in the final week of the course. Now those cases seem to suggest that the Supreme Court continues to expect medical decision making to be the key thing in relation to what they regard as medical decisions, and suggests that we should discuss Montgomery in terms of there being a big difference between informed consent questions, where those are not medical decisions, and clinical judgment questions, including diagnosis and prognosis and the choice of treatment, where Aintree and James and N against ACCG suggest that it will still be very much a matter of professional judgments reinforced by the courts. Now, it's going to take time for those Supreme Court judgments to be interpreted and settled, but you could reasonably suggest that there's been a major sea change since the string of House of Lords cases in the 1980s, which seemed to put Bolan in the ascendancy. So we're going to enable ourselves to assess whether or not the Supreme Court is shifting away from medical deference into a more activist judicial position.